She had delivered methamphetamine in Otsego County. She delivered again on July 8th. And then on July 15th, she was delivering methamphetamine again.
This was sort of a continuation of what had happened in Gaylord. Or was the second time that she had delivered drugs with her daughter present. I'm just not sure that that calls for a low point of the guidelines. I don't think there's enough aggravating factors here to call for high end either. But I do think
that intense second highlight you just watched, that is the absolute breaking point. But you haven't seen what actually led to this moment. The real story is much darker than a simple drug charge. This is Carly Price versus the state of Michigan. It looks like a standard sentencing hearing, but it's actually a tragic case of a mother risking it all. Carly tearfully claims she just wants to be a positive example for her young daughter. But how does that explain delivering meth twice, with her own child sitting right there? She desperately begs the judge for rehab, yet court records show she's already failed treatment court 2 separate times. At stake today, up to 20 long years in state prison. Subscribe to see how justice actually works and the psychological tactics most people miss in these hearings. Let's see how this unfolds.
Next, we have sentencing in People v. Carly Price. It's filed 25-7120 FH. Counsel, you want to state your appearances, please?
What's the goodness for the people?
No, and I give Ms. Price, who appears remotely from the Huron Valley Correction.
All right, so Ms. Price, as we mentioned at your plea taking, you have the right to appear in the courtroom in person for felony sentencing. If you wish to waive that right and be sentenced by video, we're happy to accommodate that. Do you know what your preference is, Ms. Price?
I will do it by video.
Okay. And you have any objection to that, Mr. Nightingale?
No.
Ms. Goodrich?
No.
All right, and Mr. Nightingale, this is sentencing on a charge of delivery of methamphetamine. It's a 20-year statutory maximum. The advisory guidelines were scored at 72 months to 120 months. Have you had a chance to review that pre-sentence report with your client?
I have, Your Honor.
Do you have any additions, corrections, or modifications?
Yes, Judge. Because what I'm noticing first and foremost is, and I'm sure the court's aware that Ms. Price is currently serving a sentence out of Otsego County. That's the reason she appears today from the Department of Corrections. I'm noticing, and this is a part of the PSI packet that Agent Martin put together, is that the guidelines for her Otsego case, which in my mind are essentially the same facts, same history, were scored much differently. So PRV 1, they had her at 25. PRV 2, they had her at 10. And then PRV 5, they had her at 5. PRV 7 is different. I can't explain that to you. But nonetheless, I do think that these would be a more appropriate reflection of her criminal history. I'm seeing what I believe are 2 scorable misdemeanors as it relates to PRV 5. I think that allowing a suspended person to operate, I don't believe is scorable. Obviously, you know, if I'm wrong, somebody please correct me. I don't want to be giving false information to the court, but nonetheless, I think that her scorable misdemeanors are from 2011, operating while intoxicated.
Can I maybe have you slow your roll a little bit there?
Sure.
I'm not just going to wholesale adopt another court's guidelines for another sentencing offense.
And
Let's take your scoring challenges one at a time.
Sure.
I'm hearing a scoring challenge to prior record variable 1.
Yes. So we'll start with the record.
So it is scored at 50 points for 2 prior high severity convictions. Ms. Goodrich, your thoughts on that? We're both flipping through here. I see a 2020. Well, a possession of methamphetamine is a 10-year, but it's a D grid. Is that a high or low severity? Oh, but you know what? You know what it would, this is why it would be. I mean, this sentencing offense, well, okay, let me look at the directions for prior record variable 1.
Yes, I was reading that very carefully. Where the offense has got to be
Committed before the conviction before the offense date.
Correct.
Okay. Prior high severity felony conviction. If the conviction was entered before the sentencing offense was committed. So the offense date in this case is July 8th. So the convictions from the offense date of July 7th, the Otsego cases that were a plea and sentencing earlier this year, those would not be scorable there, although they would, if they had scored, would certainly support that, but they wouldn't be scored. Okay, so the only one I see is the possession of methamphetamine, and that probably explains why in Otsego it was at 25 points.
That would be my argument, yes, sir.
Agent Martin, do you have any other convictions that you were using to score PRV 1? No. Okay. Ms. Goodrich, any objection then to PRV 1 being at 25 points?
No.
Okay, so we'll change PRV 1 from 50 points to 25 points. Did you have an objection on PRV 2?
I did, Your Honor.
Okay.
So PRV 2 is about the low severity felonies, I believe, and as stated previously, I know the court's not adopting a different court's sentencing.
But again, it seems that the Gaylord convictions were used to support that score.
That is what
But
I'm
the
seeing.
conviction date did not precede the offense date.
Correct.
Okay. Given that, Ms. Goodrich, any objection to PRV 2 being at 10 points?
No objection.
We'll sustain that objection, and PRV 2 will be at 10 points. And then PRV 5 at 20 points, you objected to that?
Correct.
Okay. Maybe a different issue. So this is looking at the history of which are the scorable misdemeanors.
Correct.
All right, so we've got 1 from 2011,
Yes.
2 from another 2011 would be misdemeanor 2. The MIP would not score. MIP would not score. MIP would not score. 6 out of 16 would not score. The MIPs and disorderly would not score. The suspendeds would not score, and 9 out of 16. 10 out of 16, the suspended would not score. 12 out of 16 would not score, nor 13. And then we're at the sentencing offense. So we have 2 prior misdemeanors that would be scorable. Any objection to that calculation, Ms. Goodrich?
No objection.
Okay, so prior record variable 5, I'd sustain that objection, and it would go from 20 points to 5 points then, right, Mr. Nightingale?
That's correct.
All right, and it seems as though prior record variable 7 should in fact be scored at 20 points instead of 10. Ms. Goodrich, do you have any thoughts on that?
I would agree.
No objection.
Okay. All right, so all right. So I just had to slow you down because I wasn't keeping up. Apparently
Sorry,
you
Judge.
are entirely correct, and that the prior record variables as scored in the Otsego case, we would score the same way for a total prior record variable of 60 points. Is that right? 45,
Yes.
55, 60. And that brings it to a prior record variable E. And that would, and you have any offense variable challenges?
No.
Ms. Goodrich, do you have any scoring challenges or additions, corrections?
No.
So Mr. Nightingale, would that that would indeed change it to 51 to 85 months?
Yes, Your Honor.
Okay, with that then, Mr. Nightingale, any allocution you wish to make on behalf of your client?
Yes, Your Honor, thank you. So Mrs. Price comes before the court at 32 years of age. She does have 6 prior felonies, 10 prior misdemeanors, although most of those misdemeanors are not scorable, as we've just discussed. She did receive a 51-month minimum sentence out of Otsego County for what I would suggest is essentially the same conduct. I know the recommendation here was different. I believe that's probably because the guidelines were calculated differently. I would hope this court would go to the 51 months. She's been sitting here for a couple months in Huron Valley without getting credit on this case. She's only got 2 days of credit from her initial arrest. Although this was sort of a course of conduct on Miss Price's part, I believe that Miss Price is sort of one of these folks that falls into the having to do things she doesn't necessarily want to do because she's got this habit that she needs to support. And I think Miss Price now has been hit with a very large stick. Is currently serving essentially a 6-year minimum sentence out of Otsego County. She's going to do a lot of programming while she's there. She's going to try to do as many classes as she can. She does have a job that she could go back to upon release, but I think that she's going to obviously be older at the time that she gets out. I don't think that she wants to go back to that sort of career. She's hoping to take this time seriously and to get some real skills under her belt so that she can move on in a more productive fashion upon release and successfully complete whatever parole sentence she's obviously going to get. Judge, this should be concurrent to her Otsego County case. I don't think there's any legal justification to run them consecutive. So would ask the court to run it concurrent with that matter as well. Ms. Price was trying pretty adamantly to get into some sort of treatment, into some sort of recovery court option with her out of county attorney. Unfortunately, it just didn't work out.
She's had a treatment court twice in the past,
and that's a fair observation, right? But nonetheless, the idea is she's still trying, and that was her idea here. Her attempt here was to try to go back to treatment. Obviously, the judicial system has had enough at this point, and so that was not successful for her. I don't expect that to be successful again today. I mean, she's already serving a sentence, right? What we're asking the court to do is to mirror Otsego County sentence so she doesn't have to serve longer on this case for similar conduct. Let her prove herself when she gets out on parole. And if she's serious about staying clean and getting help, then she'll do that. Thank you, Judge.
Thank you, Mr. Nightingale. Ms. Price, you don't have to make a statement today, but you're welcome to. Is there anything you want to say or no?
Yes, Your Honor. I'm here today taking full responsibility for my actions. I understand the seriousness of my offenses, including my current charges and prior convictions, and I accept accountability for the decisions that led me here. Since my arrest, I have taken my sobriety seriously and have taken concrete and consistent steps towards rehabilitation. Before coming to Women's Huron Valley, I was actively participating in weekly recovery meetings and outpatient counseling. I respectfully ask the court to consider that substance abuse treatment directly addresses the root cause of my criminal behavior, and I will be addressing that while incarcerated at Women's Huron Valley. I'm not the same person I was when I committed these offenses, although I do take full responsibility for the pattern reflected in my prior record. More than anything, I want to be a positive example for my daughter. I want to show her what it means to take responsibility, make better choices, and live a healthy and honest lifestyle. I know the path I was on is not the example she deserves, and I'm committed to changing that so she can look to me with pride instead of disappointment. I'm respectfully asking the court to consider all of that when determining an appropriate sentence today. I'm committed to my sobriety and creating a future for myself and my daughter I can be proud of. Thank you.
Thank you, Ms. Price. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. We're here because on July 7th, she had delivered methamphetamine in Otsego County. She delivered again on July 8th, this time in Sheboygan County. And then on July 15th, she was delivering methamphetamine again in Otsego County. On July 20th, during a traffic stop, it was discovered she had been traveling to obtain additional drugs. She's 32 years old. She was 17 at the time of her first arrest. Was employed before incarceration and holds a GED. She has 6 prior felonies at 32 years old, along with 10 misdemeanors. She's been in jail 7 times. Now prison and probation has been tried 6 times. On April 8th, she was sentenced in Otsego County to 51 months to 20 years. It looks like from Otis that her earliest out date is June 25th of 2030. The PSI recommendation was for the low end of the guidelines, so I would be in agreement with that continuing even with the amended guidelines. Thank you.
All right, thank you. Well, Ms. Price, these are always sad cases. I do want to say on the record, I did receive a letter of support from Ms. Price's father. I had a chance to review that. Ms. Price has got a history of, she's got a felony history. She's got a history of not just drug abuse, but drug deliveries. And most troubling to me as I reviewed this is that it looks like at least twice, one of them was this was sort of a continuation of what had happened in Gaylord. And what had happened in Gaylord the day before was the second time that she had delivered drugs with her daughter present. She's got a prior conviction where that's noted, oh my goodness. She's had treatment court twice before. So like the criminal justice system has tried really hard to work with Ms. Price. And Ms. Price, for whatever reason, that was unsuccessful. She's got an extensive history of driving while intoxicated or by alcohol or drugs or both. I don't know which, but she's got a history of driving while she's under the influence, delivering drugs with her daughter around, and 2 times at a treatment court option weren't successful. I'm just not sure that calls for a low point of the guidelines. I don't think there's enough aggravating factors here to call for high end either. But I do think that midpoint sentence seems proportionate in my mind. So Ms. Price, there's $130 as a crime victims assessment, $68 in state costs, $350 in court costs. And I'm going to commit Ms. Price to the Michigan Department of Corrections for a term of not less than 68 months, nor more than 20 years, with credit for 2 days previously served. By my math, that is the midpoint of that guideline range, the amended guideline range of 51 to 85 months. Ms. Price, if you wish to appeal, you can do so by filing an application to the Court of Appeals. If you wanted a lawyer appointed to you, I would do so, but you'd have to make that request within 6 months. We're going to see to it that your appeal rights get provided to you down in the at the prison there, and we'll ask you to send one back initialed and fill out the other one if you wish to file an appeal. Okay, good luck to you, Ms. Price.
Thank you.
The gavel dropped. Carly Price was handed a minimum of 68 months behind bars. But here is the real question. Considering her severe addiction and failed past chances, was this near 6-year sentence actually fair? Comment below Team State for strict justice or Team Carly for prioritizing rehabilitation. If this sentencing sparked a debate for you, hit like. Share this case with anyone fascinated by courtroom reality.